So we have completed just Article 14. So in today's class, let me talk about Article 15 of the Constitution. Right? So let me talk about Article 15 of the Constitution. So if you take this Article 15, so if you take Article 15, right? So if you take this Article 15, Article 15 prohibits, it prohibits prohibition of discrimination, prohibition of discrimination, prohibition of discrimination on the grounds of, on the grounds of caste, creed, place of birth, gender, religion. So these are different factors which are mentioned in Article 15. So if you look at the reason for listing all these grounds is because today we have a discrimination. Today we have a discrimination, right? So discrimination in the form of providing reservations, right? So discrimination in the form of providing reservations, right? So this discrimination is given on the grounds of these grounds, whether the kind of reservations that we have in India, the kind of reservations that we have in India, whether it is based upon the grounds of caste, creed, place of birth, gender, region, or religion. Right? So if you take this reservations, these reservations, they are not on the grounds which are mentioned in Article 15. So none of the grounds mentioned in Article 15 is used for providing reservations. So we have a different what you call parameters. We have a different criteria that is being used to provide reservations. We have a different criteria that is used to provide reservations. So what are this? What is this criteria? So if you take this criteria, these criteria includes first one, socio-economic backwardness, right? Socio-economic backwardness, social and economic backwardness, educational backwardness. It is educational backwardness. All right. So these are three different grounds: social backwardness, economic backwardness, and educational backwardness. So these are the criteria, right, which are being used to provide reservations. And remember, this criteria is not mentioned in Article 15. So what are the grounds mentioned in Article 15? So we have the grounds of caste, region, religion, gender, right, place of birth. So this is what, all right, but we don't have the grounds of socio-economic and educational backwardness. So we don't have the grounds of backwardness, right? Income backwardness, economic backwardness. So these are not mentioned in Article 15. That is the reason why constitutionally these grounds are justified in providing reservations. All right. So Article 15 prohibits discrimination only on the grounds of caste, creed, gender, place of birth, region, religion, right? So, all right, this is what about Article 15. So here, though there is prohibition of discrimination, all right, state is allowed to make special provisions. So by very first Amendment Act, special provisions are made for different categories. Say, all right, Article 15, Class 3, Class 4, they provide what you call special provisions for socially and economically weaker sections of society. All right. So special provisions are made in favor of all right, first it is in favor of women and children. All right. So state our constitution has allowed the state to make special provisions for women and children. All right. So it can be in the form of policies. All right. Women related policies, children related policies. Right. So we have different types of women empowerment, social empowerment, economic empowerment, political empowerment. Right. Similarly, safeguarding the children, the health, the education. So state has the power. So though Article 15 abolishes discrimination, but still the same constitution through Article 15 allows special provisions for women and children. All right, to socially and economically weaker sections of society. Socially and economically weaker sections of society. So weaker sections of society are given, right? Similarly, right? By 93rd Amendment Act, by 93rd Amendment Act, right? In 2005, right? So these two provisions, they were added by First Amendment Act. First Amendment Act. By 93rd Amendment Act in 2005, all right, special provisions were given for socially and educationally backward classes. Socially and educationally backward classes. Socially and educationally backward classes, right, in higher educational institutions. In higher educational institutions. All right. So by 93rd Amendment Act, in 2005, reservations in higher educational institutions were given for socially and educationally backward classes. Simply to say, all right, reservations in higher educational institutions for OBCs. All right, OBCs are given reservations in higher educational institutions. Right. So this provision was added in 93rd Amendment by 93rd Amendment Act in 2005. Similarly, by 101st Amendment Act, right? By 101st Amendment Act, reservations are given. Reservations are given for economically weaker sections of society. All right. By 101 Amendment Act, reservations were given for economically weaker sections in public employment. So these are different exemptions. These are different exemptions to Article 15. So though Article 15 prohibits discrimination, though Article 15, I'm sorry. I'm really sorry. All right. So it is not 101, it is 100th Amendment Act. It is 100th Amendment Act. 100, I'm sorry, 100 is land boundary agreement between India and Bangladesh. 101, it is 101 Amendment Act, it is what you call GS2. 102, constitutional status for National Commission for OBCs. All right. So, remember these are, so these are 103rd Amendment, it is EWS. So, NCBC, 103rd, it is EWS. So, I'm sorry. So, these are the, so actually there was a discussion in the other institution on Article 101. That is the reason why, all right, I misspelled it. So, these are important amendments. So, it is 103rd Amendment Act. It is 103rd Amendment Act, which has provided reservations for economically weaker sections of society, right? So, these are in the sequence. So, 100th Amendment Act, it is land boundary agreement between India and Bangladesh. 101 is implementation of GST. 102 is giving of constitutional status for National Commission for OBCs. 103rd, it is about providing of reservations for economically weaker sections of society. All right. So, I'm really sorry for my mistake. All right. So, this is how you should remember. So, 93rd is about what you call reservations. Reservations in higher education institutions for OBCs. Fourth one, it is 103rd Amendment Act. 103rd Amendment Act providing reservations for economically weaker sections of society. All right. So, all right. So, these are special provisions. These are special provisions made in Article 15. So, once again, I'll repeat. Article 15 prohibits discrimination on any of the grounds mentioned in Article 15. That is, discrimination is prohibited only on the grounds, whereas, all right, special provisions are allowed in favor of women and children, socially and economically weaker sections of society, socially and educationally backward classes in higher educational institutions, economically weaker sections. So, this is about Article 15. So, you need to remember both 93rd Amendment Act as well as 103rd Amendment Act. All right. So, this is about the provisions of Article 15. So, am I clear about these provisions? Am I clear about these provisions? Okay, good. All right. So, let me talk about important case law on Article 15. All right. So, when reservations are given for socially and economically backward classes. So, this issue, this issue, as I said, so these reservations were given by First Amendment Act. That is, in the in 1951, 1952, there was much debate. So, in the first 10 years of implementing of this reservation, and remember whether these reservations are permanent provisions. Whether reservations are permanent provisions. Reservations are not permanent provisions, right? So, these reservations are initially given for 10 years, right? So, the special provisions made, they are made initially for 10 years. They are initially made for 10 years. However, right, for every 10 years, these reservations are extended. All right, these reservations are extended. So, you see, extension of the reservation, extension of reservations. So, for every 10 years, these reservations are extended. So remember, these reservations are not a permanent provisions. They are not permanent provisions. So they can be extended. They are extended. Am I clear? All right. So in Champakam Dorairajan versus State of Madras case. So important case for Article 15 that we should remember is, it is Champakam Dorairajan. Champakam Dorairajan versus State of Madras case. Champakam Dorairajan versus State of Madras case. So it was in this case. Supreme Court for the first time. It was in Champakam Dorairajan versus State of Madras case. Supreme Court for the first time has justified special provisions for socially and economically weaker sections of society. Right? So it was in this case. It was in this Champakam Dorairajan versus State of Madras case. All right. Supreme Court has justified these special provisions. And remember, now why this justification? Why this justification has been given? Why this justification has been given to what you call interest of weaker sections of society. All right. So to know this, we should understand the relation between Part 3 and Part 4 of the Constitution. We should understand the relation between Part 3 and Part 4 of the Constitution. So if you look at Part 3 of Constitution, Part 3, it talks about fundamental rights. Part 3 talks about fundamental rights. Part 4 talks about DPSP. All right. So if you take this, what you call fundamental rights, the ultimate goal of fundamental rights, it is not only to protect individual freedom and individual rights. These fundamental rights aim at promoting political democracy. Fundamental rights aim at promoting political democracy, whereas DPSP, they aim at promoting what you call social democracy, social and economic democracy. They aim at promoting social and economic justice. Remember, social and economic justice, all right, that is, which is very, very important. Without social and economic justice, there is no meaning for political justice. All right? Political equality or political liberty has no meaning without promoting socio-economic equality, without promoting socio-economic justice. So they are very important, right? So DPSP aim at promoting socio-economic justice. And here I would like you to remember one important article, that is Article 38 of Constitution. Article 38 of Constitution. So if you take this Article 38 of the Constitution, Article 38, it aims at, Article 38 aims at promoting welfare state. So according to Article 38, it is the duty of the state. It is the duty of the state to promote socio-economic justice. It is the duty of the state to promote socio-economic order and establish a welfare state. All right. So Article 38 states that it is the duty of the state to promote socio-economic order, and establish a welfare state. and establish a welfare state. So this is the ultimate goal of Article 38. All right, establishment of welfare state. All right. So what do you mean by welfare state? What do you mean by welfare state? Welfare state is nothing but a society where there is socio-economic justice. We can define welfare state as a state where there is socio-economic justice. All right. So that is what DPSP says. And one of the provisions of DPSP, that is Article 46. All right. Article 46. So Article 46 clearly states that it is the duty of the state to protect the educational and economic interest of weaker sections of society. So there is a clear provision in DPSP, that is Article 46. So which states that it is a duty of the state to protect educational and economic interest. Educational and economic interest of the state. It is a duty of the state to protect educational and economic interest of the state. So now there is a provision in Article 46, all right, which imposes a moral obligation on the state. All right. So this Article 46 imposes a moral obligation. So if you take the character of this DPSP, right? So DPSP, so one of the character of DPSP is that these provisions, they denote the moral character. They are the moral obligations. They are the moral principles. So we can regard DPSP as moral principles, social, economic, and moral principles, the values. All right. So just now, for now, remember this point. So this is what the basic nature of DPSP and Article 46. So on Article 15, in Article 15, state says that there should not be any kind of discrimination. But the same time, the state has a moral obligation of establishing a welfare state by protecting the educational and economic interest of weaker sections of society. So now, whether Article 46, whether Article 46 should be given importance or Article 15 should be given importance. So this is what Supreme Court has said. Supreme Court, while delivering the judgment in Champakam Dorairajan versus State of Madras case, it has given importance. It has given importance to Article 46. So remember, initially, until Golaknath case. So in the previous class, I was talking about Golaknath case. Until Golaknath case, all right, importance is given to DPSP. Importance was given to DPSP. That is the reason why. All right, in Golaknath case, Supreme Court got fed up, right, by the actions of government. Supreme Court got serious about the actions of government restricting the fundamental rights. That is the reason why Supreme Court in Golaknath case said that fundamental rights cannot be amended. Now, have you got the reason why Supreme Court gave this drastic judgment in Golaknath case? Why Supreme Court gave this judgment? This is the reason. Because for almost all 15 years continuously, right, fundamental rights were undermined and DPSP were given importance. That is the reason why Supreme Court in Golaknath case, it has given importance. It has given importance to fundamental rights and said that fundamental rights cannot be amended. All right. So now that is how the position got changed. But later on, all right, we know about Minerva Mills versus Union of India case. All right. In Minerva Mills versus Union of India case. In Minerva Mills versus Union of India case. in Minerva Mills versus Union of India case, Supreme Court held that both Part 3 and Part 4 are two wheels of chariot of Indian Constitution. The balance between Part 3 and Part 4 is, right, the soul of Indian Constitution. So it was in Minerva Mills case, Supreme Court brought the balance between Part 3 and Part 4 of Indian Constitution. Am I clear? Am I clear why Supreme Court gave importance to Article 46? Why Supreme Court gave importance to DPSP? Why special provisions were given importance? Why special provisions were allowed? So this is the basic reason for allowing special provisions for what you call socially and economically weaker sections of society. All right. So this is what you should remember. Right. So am I clear on Article 15? Do you have any doubts on Article 15? Okay. So let me move towards the next one, that is Article 16 of Indian Constitution. All right. Let me move towards Article 16 of Indian Constitution. So if we take this Article 16 of Indian Constitution, all right, Article 16 states that there shall not be any discrimination in public employment. All right, there shall not be discrimination, no discrimination in public employment, no discrimination in public employment. All right, every individual has equal opportunity. Every individual has equal opportunity in public employment. So there shall not be any kind of discrimination. So there is no discrimination and every individual has equal opportunity. So in opportunity, there is equality, right? So opportunity is given to every individual. Opportunity is given to every individual. That is, there shall not be discrimination on the grounds of gender, place, religion, region, right, or any of the grounds. All right. So there shall not be any kind of discrimination. There shall not be discrimination on the grounds of region and all these things. All right. So every individual has equal opportunity in employment. So I am repeating the word equal opportunity. All right. So there shall not be discrimination. However, all right. So already by First Amendment Act, special provisions were made for socially and economically weaker sections of society. So now the same what you call right, a logic is used in Article 16. So even in Article 16, all right, socially and economically weaker sections of society, socially and economically weaker sections of society, socially and economically weaker sections of society, they are given importance. They are given special provisions. Special provisions were made for socially and economically weaker sections in public employment. In public employment. All right. Special provisions are made. Special provisions are made for socially and economically weaker sections of society in public employment. So there shall not, that is, though there is no discrimination, but reservations are given. Reservations are given for socially and economically weaker sections in public employment. All right. So now here we should remember one point. Reservations are given only in what you call initial employment. All right. Reservations cannot be claimed as a right. Reservations cannot be claimed, as a right, right, during promotions. So in promotions, you cannot see this reservations as a right. It is up to the state. State has every power to determine this reservations in promotions. So reservation is seen in public employment, in the initial employment, but during promotions, it cannot be seen as a right, right? So state based upon what you call the census, based upon what you call the census and the representation in public employment, based upon the socio-economic census and the representation in public employment, state can decide. It is the government that will decide whether to provide reservations in promotions or not. And this was clearly upheld by Supreme Court in Nagarajan case. In Nagarajan case, Supreme Court said that, right, the individuals cannot what you call claim, all right, reservations in promotions. So make a difference between initial employment and promotions. In initial employment, there can right, reservations are allowed. Right, reservation is a right. Whereas in promotions, reservation is not a right. It is up to the government. It is up to the government whether to provide reservations or not. So this reservations in promotions is based upon the representation of a particular caste group in the what you call in the total employment. I'll give one numerical example to make you understand. Say for example, a caste group a caste A, in the total population, it has a share of 8%. That is, in total population, right, the caste A is 8%. Right? Okay. Now, in public employment, if the caste group A has 10% representation, that is, the employees from this caste group is 10%. So don't you think that they are the representation for this A is more than their what called population percentage? So in total population, their representation is their percentage is only 8%. But in employment, right, in total employment, right, the representation for the same caste group is 10%. The people from the employees from that caste group is 10%. So don't you think that it is more than their representation? All right. Now in such case, can this caste group can claim reservations in promotions? No. Right. Now who can? So it is up to the government. It is up to the government to provide reservations. So now on what basis the government will decide? The government will decide. The government can decide. It is up to the government. Right? ఇవ్వచ్చు ఇవ్వకపోవచ్చు అది గవర్నమెంట్ ఇష్టం. ప్రమోషన్స్ లో రిజర్వేషన్స్ ఇవ్వడం ఇవ్వకపోవడం అన్నది గవర్నమెంట్ ఇష్టం. ఏ ఫ్యాక్టర్ మీద దాన్ని డిసైడ్ చేస్తారు? ఇట్ విల్ బి డిసైడెడ్ ఆన్ ద ఫ్యాక్టర్ ఆఫ్ ది టోటల్ the representation of that caste in the total population. Am I clear? So this is what said by Supreme Court in Nagarajan case. So this was said by Supreme Court in Nagarajan case. All right. So in Nagarajan case, Supreme Court held that reservations in public employment cannot be claimed as right. It is up to the government, right? It is not right, it is up to the government. All right, so this is one thing. So not only this, reservations are given for socially and economically backward classes. All right, socially and economically backward classes. So now you see a new category, that is backward classes, BCs, OBCs, other backward classes. So now this reservations for OBCs, it got implemented from 1993 in public employment. Reservations for OBCs were implemented from 1993. So there was a debate went on this. Right? Particularly in identifying the backward classes. So who are backward classes? So in Indira Shane versus Union of India case, in Indira Shane versus Union of India case, it was in this case, in Indira Shane versus Union of India case, for the first time, the Supreme Court has brought a new criteria, that is the income test. The income test was used. Supreme Court has brought a new criteria, that is income test. Right? So based upon this income test, right? So backward classes are given what you call a reservations in public employment. All right. So here an income limit is set, an annual income limit is set. All right. So yeah, Lalita, go ahead.
సార్ ఇవి కొంచెం తెలుగులో చెప్పండి సార్, అండ్ కన్ఫ్యూజన్ గా ఉంది.
తెలుగులో చెప్పాలా? రైట్. సో from 90, so am I clear about providing reservations for social and economically weaker sections?
అర్థమైంది సార్.
So from 1993 onwards, the government started providing the government started providing reservations for backward classes, OBCs. So weaker sections ante evaru? If you take these weaker sections, basically who are those sections traditionally, all right, who are seen as disadvantaged, scheduled caste and scheduled tribes, SC and ST, scheduled caste and scheduled tribes. So when we use the word weaker sections, these are traditional caste groups who are weaker. That is basically the scheduled caste and scheduled tribes. Now it is BCs, OBCs. So reservations for SC and STs, it's got started from 1951 itself. Whereas for OBCs, it was allowed from 1993. 1993 నుంచి BCs ki reservations allow చేసాం. Right? So reservations where, so these reservations are allowed in what you call public employment. 93 కి ముందు BCs కి reservation లేదు. But from 1993, right, reservations are allowed for BCs. Okay? ఈ పాయింట్ మీకు అర్థమైందా?
అర్థమైంది.
This point. So from 1993, right, reservations are given for OBCs. Right? So these reservations for OBCs were justified by Supreme Court in it was justified in Indira Shane versus Union of India case. మళ్ళీ క్లాస్ లో ఉన్నా. It was justified in what you call Indira Shane versus Union of India case. Right? So, కాకపోతే now here ఇక్కడ ఒక కొత్త పాయింట్ సుప్రీం కోర్ట్ నా to whom, to which BCs this reservation should be given, whether all the BCs or should there be any criteria to identify the BCs which requires what you call employment, which requires reservations. అందరి బేసిస్కి ఇవ్వాలా లేదా నీడీ వాళ్ళకి ఇవ్వాలా? So Supreme Court has brought a new parameter for providing reservations. All right. So what are that parameter? It is those BCs who fall below certain income level. So that is an income test was used, an income criteria. All right. So for providing scheduled caste and for providing reservations for scheduled caste and scheduled tribes, it is the what you call traditional what you call the caste system. The caste was used. For SC STs, it is caste was used. But now for OBCs, it is not caste. It is income. Those OBCs who fall below certain income. All right. It is only that BCs, not all the BCs. Under BCs gado. It is not for all the BCs. It is only for those BCs who fall below, all right, certain income level. All right. So initially it was given as 2 lakhs per annum. The one who fall below this 2 lakhs per annum, they are given what you call reservations. And every year, for every 3 years, 4 years, the government went on changing this income test. Now today the income test is 8 lakhs. Right? Who, that is the OBCs whose annual income is less than 8 lakhs, they can claim reservations. The same thing is applied in UPSC. The same thing is applied in UPSC. Okay. So not all the OBCs, it is only those OBCs whose annual income falls below this what you call income test. Now it is 8 lakhs. It is 8 lakhs. Those what you call whose annual income falls below this 8 lakhs, they are given what you call reservations in public employment. All right. So the amount of reservations given for OBCs should not exceed 27%. The amount of reservations that is given for OBCs should not exceed 27%. All right. And the total amount of reservations for OBCs is 27%. అంతకుమించి exceed అవ్వకూడదు. Am I clear? All right. So this is what about reservations for OBCs. Right. So it is from 1993. It was justified by Supreme Court in what you call Indira Shane versus Union of India case. And the amount of reservation is 27%. Reservations are given for only those OBCs who fall below the what you call the income test. Right. So these people, these OBCs who fall below the income test, they are called as non-creamy layer. They are called as non-creamy layer. They are called as non-creamy layer. Now we have two things, creamy layer and non-creamy layer. We have creamy layer and non-creamy layer. We have creamy layer and non-creamy layer. Okay. Creamy layer means what? Lalita, what do you mean by creamy layer?
High income families, sir.
Above the income test. Above the income test, they are called as creamy layer. And the one who are below the income level, they are called as non-creamy layer. Now to whom the reservations are given?
Non-creamy layer.
Reservations are given for non-creamy layer. So this is a new innovation in Indian judiciary, in Indian society. So Article 16 provides reservations for socially and economically weaker sections. At the same time, reservations are given for the OBCs who are non-creamy layer, who fall below the income test. All right, am I clear till now?
Yes, sir.
Okay. So next, as I said, by 103rd Amendment Act, 10% reservations are given for economically weaker sections in public employment. So by 103rd Amendment Act, by 103rd Amendment Act, right, 10% reservations, 10% reservations are given for 10% reservations are given for what you call economically weaker sections of society in public employment. All right. So these are different groups. These are different groups who are given special provisions in public employment. All right. So though Article 16, what you call prohibits discrimination in public employment, though Article 16 promotes equality in public employment, but still special provisions are made for what you call socially and economically weaker sections. What you call socially what you call other backward classes. Reservations are given for other backward classes. Reservations are given for economically weaker sections. All right. So this is what we should remember. And one important point that we should remember is part 16. When you read Article 16, also keep in mind the importance of part 16 of Indian Constitution. So what is this part 16 says? What does this part 16 says? Part 16 of Indian Constitution. So part 16 provides special provisions for certain groups in India. Special provisions for scheduled castes, scheduled tribes and Anglo-Indians. Part 16 provides special provisions. So special provisions for scheduled castes, scheduled tribes and Anglo-Indians. All right. So here we have certain important provisions. Say Article 330, Article 332, Article 335, Article 338, 338A. All right. So these are important articles that you should remember. Very, very important. All right, to remember. All right. So these are the articles which provides reservations for scheduled castes, scheduled tribes in what you call public employment. Article 335 provides reservations for scheduled castes and scheduled tribes in public employment. Whereas 330 and 332, it is in legislative bodies, in parliament as well as in state legislature. Right? Am I clear? So Article 330 provides reservations in parliament, 332 in state legislature, 335 in public employment. Right? So these are the special provisions. So that means already through part 16 of Indian Constitution, already through part 16 of Indian Constitution, all right, special provisions are made. Special provisions are made, all right, for scheduled caste and scheduled tribes in public employment, right? And these are implemented by using Article 16. So Article 16 provides the same thing. Okay. So reservations for scheduled caste and scheduled tribes, they are originally mentioned in Constitution in Part 16 of Indian Constitution. All right. Am I clear on the relation between both Article 16 and Part 16 of Constitution? All right. So this is what you should remember. Right. So here the important case law is Indira Shane versus Union of India case. So one is Indira Shane versus Union of India case. Another one is Nagarajan versus State of Tamil Nadu case. All right. So it is both these cases. One is Indira Shane case. Other one is Nagarajan case. All right. So don't forget to remember these case laws. All right. So this is about Article 16. Any doubts on Article 16? Okay then. So next, let me move towards Article 17 of Indian Constitution. Let me move towards Article 17. So Article 17 abolishes untouchability. Abolition of untouchability. All right. So if you take Indian society, traditionally Indian society is a stratified society. Traditionally, Indian society is a stratified society. It is a stratified society. Okay, that means there is a stratification. All right, and right from the ancient times, a social disability is imposed. Right, a social disability. A social disability is imposed on certain caste groups. Social disability is imposed on certain caste groups. Certain caste groups. All right. So what is this social disability? All right. So I think you have idea about this kind of disability that is imposed on certain caste groups. That is those who are regarded as disadvantaged sections, deprived sections of Indian society. They are not allowed to use public infrastructure to take public water facilities, wells, lakes, educational institutions, right, parks, and even they are not allowed to enter into temples. Certain caste groups in India, historically, they are not allowed to enter into temples. Do you have idea about these kind of things in Indian society? At least, have you heard about these kind of things? Okay, so you have an idea, you have heard about these kind of things, right? So there is a kind of disability. So people were not allowed to enter into public parks or any public facility. All right. So this is what the meaning of social disability. Remember, though our constitution abolishes untouchability, though there is abolition of untouchability in what you call Indian Constitution, the word untouchability is not exactly defined in the Constitution. Right? The word untouchability. The word untouchability not exactly defined in the Constitution. It is not defined in the Constitution. The word untouchability is not exactly defined in the Constitution. All right. So it is in Chitralekha versus State of Mysore case. Chitralekha versus State of Mysore case. It was in this case, in Chitralekha versus State of Mysore case, Supreme Court for the first time, it has defined this word untouchability. It has defined the word untouchability and said that untouchability is a practice of imposing social disability, right, on the grounds of caste. Imposing social disability on the grounds of caste. All right. So that is how the untouchability is defined. And in 1955, the government of India has passed Untouchability Offences Act. All right. It is in Untouchability Offences Act. It is in Untouchability Offences Act 1955. So it is this act, right, which has come up with different grounds, right? It has come up with different grounds of untouchability. So it is this act which laid down different grounds which are regarded as untouchability, acts of untouchability. So what are these grounds? Preaching untouchability, all right, preventing a person from entering into public places, then punishing a person in the name of caste, right? So these are the initial grounds. So initially preaching, preventing, punishing. Later on in 1976, so this Untouchability Offences Act of 1955, it was amended in 1976. Amended in 1976, right, which is called as Untouchability Offences Amendment Act, right, which is called as Untouchability Offences Amendment Act, which has broadened the scope of definition of untouchability. So in 1976, the definition of untouchability was broadened and some more grounds were added to this what you call untouchability. Earlier it was preaching, punishing and preventing. Now justifying untouchability, supporting untouchability, even they are not only the direct acts of untouchability, but even indirectly, any form of support given to untouchability, they are seen as a criminal acts. So any form of untouchability is seen as a criminal act according to this 1976 Untouchability Offences Amendment Act, right? So originally there is no definition of the word untouchability. This word untouchability was defined by Supreme Court in Chitralekha versus State of Mysore case, and the government of India first time in 1955, that is by way of Untouchability Offences Act, it has defined the word and given certain grounds as acts of untouchability, which were later expanded in 1976, right? So and made any act of untouchability as a criminal act. All right, am I clear? So this is about Article 17.
Yes, sir.
Okay, so for now I'll stop the class on this Article 17. All right, so I hope you have understood today's class. So today we have discussed Article 15, Article 16, Article 17. All right, so for now I'll stop the class here. All right, we'll meet in tomorrow's class.